I just want to update you on this new case that came out because it's important to see that things are going in the right direction regarding the odor of cannabis. The odor of marijuana right now, if a cop smells it, guess what? They get to search your pants, your car, your trunk, your purse, you name it, because they are looking for contraband. Now, if you have a medical card, that can help, and maybe they don't get to. But this Baxter case that just came out, I wanted to call to your attention because Baxter files a motion to suppress. His car is searched after the cop smells weed, and they find a bunch of weed, right? And Baxter is saying, look, I don't think that this law is relevant anymore now that we've legalized hemp. With hemp being 100% illegal, you can't differentiate hemp from marijuana. Therefore, you don't know whether there's an illegal substance in my car. Are you smelling legal hemp or are you smelling legal marijuana? And the Baxter, this went up on appeal to the 5th DCA in this case that I'm showing you now. And the court did uphold Baxter's conviction. But why I'm pointing this out to you is we're seeing the shift. And the shift comes, first of all, with Judge Wallace, who I like. And Judge Wallace is concurring. In other words, Judge Wallace is like, yeah, the motion to suppress should have been denied. This conviction has got to stand. But Wallace is starting the shift. And you'll see that in his opinion here where he says, I write to highlight a concern created by the enactment of the state hemp program in 2019, which we talked about. And he says there is some confusion about whether officers in Florida still have reasonable suspicion to go rifling through citizen stuff when they smell something that they think is an illegal marijuana situation. And he says, he poses this question to a higher court. Look, does this, in other words, he's telling the court system, would y'all answer this question, please? Does the plain smell doctrine still apply such that smelling cannabis is itself sufficient to establish reasonable suspicion and reasonable cause? I say it's not. I've been saying that it's not ever since they passed the hemp law. These things take a while. It was 2019. This should have been changed in 2019, but it's not. But you can see Wallace saying we need to get there, or we're at least needing some guidance here. But then I'm going to scroll down here. Judge Kilbane is straight up dissenting on this issue. Kilbane still says you can deny suppression in this case on other grounds. But Kilbane says in terms of the plain smell doctrine, this has got to go. And I'll try to find the highlight. But let's see. Yeah, like page 17. The issue is, in light of the dramatic changes to Florida law and federal law regarding hemp, the smell of what is believed to be marijuana alone continues to provide reasonable suspicion for investigatory detentions. And eventually the judge is saying it shouldn't, really should not. And here's what we've been talking about. The judge indicates, look, the smell of hemp and marijuana cannot be distinguished. They look, feel, and smell the same. There's just no way to tell these things apart. And this is the key phrase. This means that law enforcement who smells an odor of marijuana can no longer immediately know whether it is emanating from legal hemp, legal medical marijuana, or illegal marijuana. As a result, the basic tenet behind the court's adoption of the plain smell doctrine no longer applies to the smell of marijuana. We got to stop doing this, is what the dissent is saying. We can't keep searching Florida citizens because some cop smells what he thinks is marijuana. That's not the law yet, but we are getting close. I wanted to point out this Baxter case just to show you how close we're getting. Even the judges are recognizing this in their dissents and their concurring opinions.